ఇప్పుడు ఒకసారి లింక్ వస్తుంది. ఇప్పుడు వస్తుంది. One second. లైవ్ వెళ్తుంది. ఊరుందా? ఇంతకంటే ఎక్కువ. కరెంట్ వ్యూవర్స్ 20 వ్యూవర్స్ వచ్చారు. సెకండ్. Streaming software, get shareable link. ఈ లింక్ వచ్చి చూడండి. ఇప్పుడు ఒక లింక్ పెట్టారు. యా వీఆర్ గోయింగ్. ఇప్పుడు వేరే లింక్ పెడుతున్నా. ఆ లింక్ స్టూడెంట్స్ చూస్తారు. నేను మాట్లాడంత స్టూడెంట్స్ కనిపిస్తారు. వీఆర్ లైవ్ కదా, స్టూడెంట్స్ వింటారు. యా స్టార్ట్ చేయండి. నేను చూస్తా.
Good morning, all my dear students. Today's class about jurisdiction. Today's topic related to jurisdiction, bar of suit, res sub judice. That is one more subject. One more topic is res judicata and place of suing. This is what the topic I am going to discuss today. Meaning, the term jurisdiction has not been defined in the code. The word code jurisdiction is derived from Latin terms juris and dicto, which means I speak by the law. Stated simply, jurisdictions means the power of or authority of a court of law to hear and determine a cause or a matter. It is the power to entertain, deal with and decide a suit and action petition, or other proceedings. Here, what exactly the meaning of the jurisdiction is nothing but the court is having the authority to determine the cause or matters. It is the power to entertain. It is having the power to entertain, deal with, and decide a suit or action or petition or other proceedings. So, in other words, by jurisdiction is meant uh, by jurisdiction is an authority which a court has to decide matters that are litigated before it, or to take cognizance of matters presented in a formal way for its decision. Coming to various kinds of jurisdiction. Jurisdiction of a court may be classified under the following categories. So, please look into this: civil and criminal jurisdiction, and the second one is territorial or local jurisdiction. Third one is pecuniary jurisdiction. Fourth one is jurisdiction has to subject matter. Fifth one is original and appellate jurisdiction. What about the civil and criminal jurisdiction? Here is the explanation. Civil jurisdiction is that which concerns and deals with dispute of civil nature. So it is concerned always about the civil nature. And coming to the criminal jurisdiction, this is about, on other hand, relates to crimes and punishment of offenders. In anything, the person have done the offense, so that he is subject to the punishment. Coming to the territorial or a local jurisdiction, every court has its own local or territorial limits beyond which it cannot exercise its jurisdiction. These limits are fixed by the government. So whatever the territorial jurisdiction I'm speaking, this limits has been fixed by the government. The district judge has to exercise jurisdiction within his district and not outside it. The High Court has jurisdiction over the territory of a state within which it is situated and not beyond it. Again, a court has no jurisdiction to try a suit for immovable property situated beyond its local limit. So, even the High Court also having the jurisdiction over the territory of a state within its limit. Okay, and coming to the pecuniary jurisdiction, what about the pecuniary jurisdiction? Even section 6 deals under CPC about pecuniary jurisdiction. The code provides that a court will have jurisdiction only over those suits the amount or value of the subject matter. So I repeat, the suits only deals about, when the person wants to file a suit, so it is based on the amount and value. The jurisdiction will be decided based on a pecuniary, okay, pecuniary matter, that is the subject matter decided based on the pecuniary limits. Some courts have unlimited pecuniary jurisdiction. For example, I can tell you High Court and District Court have no pecuniary limits at all. But there are other courts having jurisdiction to try suits up to a particular limit. For example, Presidency Small Cause Court and Provincial Small Cause Court. That again comes under section 8. Okay. And coming to the jurisdiction as to subject matter. What about the jurisdiction has to subject matter? Different courts have been empowered to decide different courts. We have already discussed different courts have been empowered to decide different types of suits. Certain courts are precluded. It means they do not have the jurisdiction to try the case. Precluded from the entertainment of certain suits. Thus, for example, I can say you Presidency Small Cause Court has no jurisdiction to try suits for specific performance of a contract. I can tell you example like not only specific performance of a contract, we can say that even a partition of immovable property, foreclosure or redemption of a mortgage, etc. Similarly, in respect of testamentary matters, divorce cases, probate proceedings, insolvency proceedings, etc., only the district judge or civil judge, senior division has the jurisdiction. You understood? So jurisdiction has to the subject matter. It is based on the, for example, divorce case. So the petition should be filed in a family court. Likewise, different cases, categories of the cases are there. It can be filed in a separate and specific courts. So this is called the subject matter jurisdiction. And coming to the original and appellate jurisdiction, original jurisdiction is jurisdiction conferred upon a court of first instance. It is original jurisdiction. Yesterday I have already discussed original jurisdiction means suit. If the person wants to file a suit, where he is filing very in a first instant, though it is a a subordinate courts, or if it is in a district court, or if it is in a high court, or high court and basically Supreme Court both is having a writ jurisdictional. If the person is filing the writ jurisdiction directly to the so and so court, then it is called the original jurisdiction. And coming to the appellate jurisdiction is nothing but it is not subordinate court will not applicable for the appellate jurisdiction, but because even here a subordinate court will not deals with the appeal cases, right? So I said you the example about section 96 and as well as section 100. So it is a section 96 deals with the first appeal, and the second appeal deals about under section 100. So here the first appeal goes to the district court and the second appeal goes to the high court. Even in the high court there is a again first appeal and second appeal. So that is when you are coming to the practical, you will understand. For suppose now you want to understand about the original and appellate jurisdiction, this is what the suit in the first instance, wherever the person is filing the suit or petition or application, now it is called the original jurisdiction. If you understood, we will go to the next topic, that about section 9 of jurisdiction of the civil code. As I said, section 9 is the entry gate to this CPC. So it is entry gate CPC. I can say section 9 is a very important. So I can tell you under the code of the civil procedure, a civil court has jurisdiction to try all suits of a civil nature unless they are barred. What is nothing but barred? It means like it is the person who couldn't able to file based on so and so things. So that is called barred. And coming to the what about exact explanation, the court shall, subject to the provisions herein contained, have jurisdiction to try all suits of a civil nature except suits of which their cognizance is either expressly or impliedly barred. In case, for example, expressly, if there are any provisions which has been legislated, the act has come, it came into the existence, and it is expressly stating that this these suits cannot be filed in so and so, so that is not applicable. For impliedly barred, it is nothing but if the person who got any kind of already remedy, he got it, so then it is nothing but impliedly barred. It simply if particular person, if any private person, he got already particular compensation or something, he has been already claimed, so this all comes under impliedly barred. It means that though there is no provision also, so impliedly you can take into that particular thing into that consideration. Okay, and coming to the explanation part, explanation 1 says about a suit in which the right to property or to an office is contested is a suit of civil nature. Yesterday I have explained. So right to property or to an office, it is contested in a suit of civil nature. For example, it is not withstanding that such right may depend entirely on the decision of question as to religious rites or ceremony. I gave you the example, like one case law I have said, that is if the person is claiming for any honors, so that will not applicable. It means it is completely based on the religious matter, so it will not applicable. That case law I've quoted yesterday. Okay, we'll see subsequently. I will let you know what the case law it is. Now coming to the explanation part 2, that is for the purpose of this section, it is immaterial whether or not any fees are attached to the office referred to in explanation 1, or whether not such office is attached to a particular place. If the office is not attached to the particular place, so it is not also, it will not applicable. For explanation, it clearly states that the condition is very clearly states that in a civil court, if you want to file any suit, so that should be a subject to the two conditions. One is that should be a civil nature, and the other one is the cognizance of a such suit should have been expressly or impliedly barred. So this is what suits in a civil nature. If you understand what is the suits in a civil nature or what not comes under the civil nature, you will understand that what exactly a cognizance of the civil nature. Okay, the following suits conditions, suits sorry the suits or suits of civil nature, that is suits relating to rights to property. One is suits relating to rights in property, in case any rights they wants to claim, the person wants to claim. So it is applicable, like he can go and he can file a suit. And suits related to the rights of worship, as I said, if it is completely based on the religious rights, so then it cannot, based on if they want to claim any honors, so that is that will be that cannot be entertained in the civil court. And coming to the suits relating to the rights of worship, for example, I can tell you Sabarimala case. Sabarimala case, what exactly the petition? So they want to enter into the court. Women should enter into the temple. Okay, this is what they have claimed the right. So these kind of rights can be claimed in a under the civil nature. And coming to the third one, suits relating to talking out of religious processions. So out of the religious procession, every suits can be. For example, even Ram Bhumi case. So Ram Leela, so Ram Janmabhoomi case. It is also out of the religious processions, like based on the construction. So it can be. And coming to the suits relating to right to share in offerings. So any shares of offerings, so that can be filed. And suits for damages for civil wrongs. Suits for damages for any civil wrongs. So civil wrongs, where generally we speaks in torts. So torts, whatever the civil wrongs, that can comes under the civil damages. So that can be filed in a court of civil. And suits for specific performance of contracts, or for damages for breach of contract, any damages occurred, breach of contract. So these kind of cases also can be filed in a civil court. And coming to the suits for specific relief. So specifically, if you are asking for example, you asked for construct the building, you came into the agreement and you gave the particular work to some other person, but he failed to do so. So specific relief can be claimed based on that. If any damages are sustained because of the construction has not been done in a particular time when you have expected, so specific relief can be claimed. I am giving you example, many specific relief can be claimed in a many cases. So coming to the eighth point, that is suits for restitution of conjugal rights. Suits for restitution of conjugal rights, that is if wife or husband, either of the wife or husband, if they left without any reason, they can ask for the restitution of conjugal rights. They can ask for, please come back, like what exactly the issue, so we will rectify it, and we want to live a happy life together. So that is a restitution of conjugal rights, again comes under the Marriage Act, so section 9, I believe. So there restitution of conjugal rights can be filed. And coming to the suits for dissolution of marriage, divorce. So any case divorce wants to file, dissolution of marriage can be filed in a civil nature. It won't come under criminal nature. Suits for rents, suits for an accounts, or suits for right of franchise, suits for right of hereditary offices, suits against wrongful dismissal from service, or for any salaries. So this and all comes under suits of civil nature. Then what are the suits not a civil nature? Here it is. The following are not suits of a civil nature. What are that? Suits involving principal caste questions. Any caste based questions has been raised. So it is a so then this will be not applicable in the civil courts. So they cannot file the case in civil nature. And it is not and coming to the second one, suits involving purely religious rites or ceremonies. As I discussed, any honors they wants to claim, so that is the best example for the religious rites and ceremony. So these kinds of suits will not be entertained in the civil code. And coming to the suits for upholding mere dignity or honor, any dignity or honor they wants to claim, then it also will not comes under civil nature. Suits for recovery of voluntary payment or offerings. So suits for recovery of voluntary payments, any payments or offerings, so that cannot be claimed. And suits against expulsion from caste, so any expulsions from the caste also, that cannot be claimed. Many cases are there. So like this, suits not comes under the civil nature. Then coming to the case law, that is Sinha for religious rites or ceremony, Sinha Ramanuja versus Ranga Ramanuja. That is Sinha Ramanuja versus Ranga Ramanuja. In this case, particularly a person claims for the honor. So court will finally says that it will not comes under civil nature. So hence it will be dismissed. Okay, and coming to the suits objections to jurisdiction. Objections to jurisdiction, section 21 and section 21A. We spoke about the objections regarding joinders and joinder of the parties, joinder of claims, and joinder of cause of action. Here, objection to the jurisdiction. Don't forget the section 21 and section 21A. Okay, in between the sections which is comes for the place of suing, that we will discuss. Before that, we have to understand what objections to the jurisdiction. According to the section 21 of the Code of Civil Procedure, the code deals with the question of objection relating to the place of suing. Place of suing, we will see that under the sections 15 to 20. So the next one is the place of suing. The second one is the competence of a court with reference to the pecuniary units, and third one is the competence of executing courts with reference to the local limits. So any competency of the court with reference to the pecuniary units, so then it will be objections. For example, instead of filing in higher court, if the sub court has been entertained the court which is beyond the limits of that particular thing, then it will not applicable. So hence that suits will be returned, and they have to file it in subsequently in a specific court where it is subject to entertain. Okay, and coming to the third point, the competence of the executing court with reference to the local limit. So any local limits is there, executing court at the time of after the completion of the decree, any execution proceedings is there, and with reference to the local limits, then it is there will be objections. Okay, and coming to the an objection, to understand this topic, an objection to jurisdiction shall be raised at the earliest opportunity. If the person is raising any objections, so the person should raise it in earliest opportunity so that the other party can approach the appropriate forum. So then that person is having the liberty to go and approach the particular forum. Okay, though it can be raised at any stage of the suits or appeal or execution proceedings. If the person is raising in a very first instance at that stage of even at the suit or appeal or execution proceedings, and even in a appeal after remand, omission to raise objections will not confer the jurisdiction in the court, where in law it does not have, and therefore it is the duty of the court to consider whether it has jurisdiction or not. Maybe here the person who forgot, otherwise he couldn't identify whether this particular case can be dealt in particular in this court or not. He did not raise the question, and he omitted to raise it. The objection, he omitted to raise it. Now it is not that one particular jurisdiction is dealing the case. It cannot say that that is not having the competent jurisdiction if the person is not raised. Otherwise, a court is also having the responsibility to see and consider the based on the jurisdiction. In case if the court also identifies, and it should return the plaint or suit to the person, and direct that person to file in so and so court. Okay, and this is what exactly if the omission has not raised. If the person raising the omission, that should be in earliest stage, and if the person is not raising the particular objections to the jurisdiction, then it is not precluded. The court can decide the case, but even the court also having the equal responsibility to check the jurisdiction, and it should inform them. Okay, and where an objection to the jurisdiction of a civil court is raised to entertain a civil suit and pass any interim orders, it has to pass any interim order, and the court should decide the question of jurisdiction in the first instance. So here the court also having the responsibility to take objection to the jurisdiction in the first instance itself. But that does not mean that pending the decision on the question of jurisdiction, the court has no jurisdiction to pass interim orders. For example, already the parties have raised the jurisdiction objection to the jurisdiction you feel. Then if there are any objections, it has not yet decided in case some question of law has been raised. Okay, if the court has not decided whether the jurisdiction is there or not to deal this, and it is not that court is not having the jurisdiction to pass any interim order in between, it has not decided, it is in pending, you think at that time a court can pass any interim order. They cannot challenge this interim is not valid one because of it, that court is not having the jurisdiction. It can, it is nothing but it is an exemption, as may be called, for the facts and circumstances of the case, based on the facts and circumstances of the case. And coming to the res sub judice and res judicata, it is section D. Section 10 deals with stay of suits. Stay of suit is nothing but res sub judice. What about res sub judice? Section 11 speaks about res judicata. What about res judicata? In general, in this chapter, we intend to discuss two important doctrines. That is what? That is res sub judice, and that is under section 10, and doctrine of res judicata, that is section 11. Section 10 Section 10 deals with the stay of civil suits. It provides that no court shall proceed with the trial of any suit in which the matter in issue is also directly or substantially in issue in a previous instituted suit between the same parties, and the court in which the previous suit is pending is competent to grant the relief claimed. What exactly it is? See, here what they are saying is the issues should not be directly or substantially. One thing, stay of suit is nothing but already one case has been filed in a particular court. Okay, the person, or he wants to do some mischief and he wants to obtain the decree in his favor. What he have done, without informing, he also filed the same case into some other court, in the some other court. Now it is coming to the question to stay in a subsequent should be stayed. Okay, based on if the issue, if the court finds that if the issue directly or substantially, okay, it has been raised in the previous by the same party, by the same cause of action, now the subsequent suit should be stopped. It means they have to kept it stay, and they have to give chance to the first instant court to decide. But if it is coming to the objections to the jurisdiction, that is different, that I will discuss later. And coming to the conditions, there must be two suits. What you have to understand for the stay of suit, you have to understand there must be two suits, one previously instituted and the other subsequently instituted. Previously, if any case has been instituted in so and so court, and the same case has been instituted in subsequently, okay, and the matter, now you have to check it, the matter in issue in the subsequent suit, it means previous suit, must be directly and substantially in issue in the previous suit. If the same question, or see, sometime maybe it is a direct, or sometime maybe it is applicable, like substantially, like it is same, relevant to that, maybe they have changed the topic, maybe they are claiming the same prayer. So that kind of issues they are raising in both the cases. The both suits must be between the same parties or the same representative. Now it can be, it is it can be, we can, you can say that, this is comes under the res sub judice. It means we can stay the suit. So, the later or subsequent suit can be filed, that can be stopped. And coming to the fourth condition, the previously instituted suit must be pending in the same court. So you have to understand there should be pending. It means there is no adjudication. No adjudication means the court has not decided it. It is still, it is in a trial or something pending. Pending is there. It is not continuing the proceedings. So it is pending. And the same court in which the subsequent suit is brought, or in any other court in India, in any court beyond the limits of India, established or continued by the central government or before the Supreme Court. So this is what you have to keep it in a mind. to understand what exactly, when the suit has been instituted previously or subsequently, that is should be under the same parties and the same cause of action. That issue has been raised maybe directly or indirectly, and this is subject to the stay. Okay, the court in which the previous suit is instituted must have jurisdiction. As I said, if there is a lack of jurisdiction, then it can be put it in a proper place. But if it is having the proper jurisdiction, it means the suit is tried by the competent jurisdiction to grant the relief claimed in the subsequent suit, then such parties must be litigating under the same title in the both the suit. Then it is comes under the res sub judice. These all are the conditions you have to understand. And as soon as the above conditions are satisfied, a court cannot proceed with the subsequently instituted suit. So immediately the court, subsequent suit has been instituted now. Since the provisions contained in section 10 are mandatory and no discretion is left with the court. It is, however, necessary that for section 10 to be attracted, it is an essential that entire subject matter in controversy must be the same between the previous suit and the subsequent suit. Coming to the res judicata. Res judicata section 11 on the other hand relates to a matter already adjudicated. So here in a res sub judice what we have spoke, the suit is in pending. But here in res judicata, in previous case has been decided, adjudicated. They have got the judgment and they have got the decree. Everything has been completed. If the case already adjudicated, it bars the trial of a suit or an issue in which the matter directly or substantially means even if it is it is some similar to that, an issue has already been adjudicated upon in a previous suit, then it is comes under res judicata. The meaning of res judicata: res means subject matter or dispute, and judicata means adjudged, decided or adjudicated. Res judicata means a matter adjudicated or a dispute decided. Okay. The principle is also founded on justice, equity, and good conscience, which require that a party who has once succeeded on an issue should not be harassed by multiplicity of proceedings involving the same issue. It has been already decided. Then again, subsequently, if the person is allowed to file the case and he can proceed with the case, means it is actually a right is infringed on the other side party. So now he should not be harassed because of the multiplicity of proceedings. Okay, this is what the object of this section. Section 11 of the code contains in a statutory form. It embodies the rule of conclusiveness and operates as far as to try the same issue once again. It thereby avoids vexatious litigation. Okay. And coming to the what are the main object in this, you might have know this. What are the three maxims? That is nemo debet bis vexere pro una it idem causa. What exactly the meaning of this? No man should be vexed twice for the same cause. Got it? And coming to the second point, that is interest republici at sed finis litium. Okay, what is the meaning of this? It is the interest of the state that there should be an end to a litigation. So there should be end to the litigation. And coming to the res judicata pro veritate occipitur, it is a judicial decision must be accepted as correct. Okay, the whatever the judicial decision must be accepted as correct. And coming to the section same 11 of the CPC, explanations about no court shall try any suit or issue in which the matter directly or substantially in issue has been directly or substantially in issue in a former suit between the same parties. Former suit means already previously instituted. Former suit means previously instituted case already adjudicated. Now subsequently, person should not file it, and if files it and it is subject to the res judicata, or it is like this. If between parties under whom they are, or any of them claiming or litigating under the same title in a court competent to try such subsequent suit of the suit in which such issue has been subsequently raised and has been heard and finally decided by such court. It's already decided. And coming to the explanatory part, so this is very, very important for the exam point of view. So here you will be having totally 8 explanations. What about the first explanation? Speaks about the expression former suit. Please make a note. Former suit shall denotes a suit which has been decided prior to the suit in question, whether or not it was instituted prior thereto. What exactly the former suit means? If you are finding out if the person has been raised, no, this case already filed in so and so court and it has been decided, and without knowing you have instituted a suit, you being an advocate, you have instituted a suit, otherwise, the person opposite party has been instituted a suit, then you can raise this question. It is already decided. The former suit, who has to raise? Only opposite advocate, opposite party should raise the question. So it should be a former suit. So former suit is, you have to make a highlight on this explanation part 1. And coming to the explanation part 2, for the purpose of this section, the competency of a court shall be determined irrespective of any provisions as to right of appeal from the decision of such court. So here you have to highlight the competency of a court. If the case has not been decided in a competency court, then with the permission of the court, again they can institute. But if it is a competency of the court, then they cannot. So you have to highlight here the competency of a court. Okay, competency of the court. I will ask in future, like, what is the explanation under section explanation 2 under section 11. So now you have to say, at least if you don't even say that entire content, I want the exactly the word which I am saying to highlight it. Okay. And coming to the explanatory part 3, the matter above referred must in the former suit have been alleged by one party and either denied or admitted expressly or impliedly by the other. For example, it is like, you need to see that former suit has been instituted and the parties are the same and the allegation is the same. This is what the meaning here it is saying. So here you need to highlight allegation by one party and either denied or admitted or expressly or impliedly by the other person. Now you have to understand the same parties. In the former suit, what you have to understand, whether the subsequent suit has been instituted by the same party or not. Then the explanation will come under where? Explanation 3. And coming to the explanation 4, what explanation 4 speaks about? Any matter which might and ought to have been made ground of defense. Now you have to check ground of defense or attack in such former suit. You have to see defense means, again, the cause of action. What kind of the defense they have taken, cause of action or prayer. Sorry. Here you need to highlight the matter directly or substantially in issue. See here in the next line, former suit shall be deemed to have been a matter directly and substantially in issue in such suit. So now if it is directly or substantially the issue has been raised in a subsequent suit, then you can catch it, that is a that comes under so and so res judicata. Coming to the explanation part 5, that is any relief claimed in the plaint. You think that any relief already claimed in the plaint or not expressly granted by a decree shall for the purpose of this section be deemed to have been refused. 3 days back when sir raised the same question. If in case the cause of action, in case any claim has omitted by the court, then what I have to do? In case, court omits, it means like expressly or impliedly, expressly it is not granted, you think, then you cannot go for, the court forgot this, please, I want to claim the relief, which the court not given any relief on particular cause. Okay, then it is deemed to be refused. It means court is voluntarily refused it. Then again you cannot raise the question In case if you are filing the case based on the court already granted a decree where the relief has been omitted by the court. Now it is seemed to be that seems that it is deemed have been refused. Deeming means it is clearly stating that the court is not granting any relief, so you cannot go and challenge it, otherwise you cannot file a fresh suit based on the omission. Okay, and this is what this is also comes under the res judicata. These kind of cases also you can see, it is not only the suit the same fact of the case, and even after decree also people will come based on that question. Now they says that no sir, that allegation is different, and this allegation is different, that grounds is different, but here court voluntarily refused to give the you cannot mention that it is a voluntarily, but if the claim has been decided, if I couldn't able to obtain this claim, so now that is the reason I have filed this suit. And even by foolishly you should not take the case in that manner. In case already court has been decided, and you have to educate the client that it is refused, it means it is deemed to be refused, you cannot claim it. Okay, you can challenge it, in appeal court, but you cannot file a fresh suit. Okay, this is what I mean to say here. Coming to the explanation part 6, here in this explanatory part 5, where you have to highlight means deemed to be refused, that you have to highlight. And coming to the explanatory part 6, where a person litigate bona fide, in respect of a public right or a private right claimed in common for themselves. In common for themselves means what? You just remember where we have spoke order 1 rule 8. What is that order 1 rule 8? That is representative suit, right? It is a common for themselves. Here it is speaking, explanatory part 6 is speaking about the representative suit. Okay, if the person is already claimed on behalf of mass people, all person interested in such right for the purpose of this section be deemed to claim under the persons to be litigated. In now, if the one person now again coming and he is saying that I did not claim this so and so the cause, so then he wants to file the case subsequently. It is stated that clearly stated that deemed to be claimed. It already every person is having the same applicability. If any court passed an order or any judgment has been passed in the representative suit, whoever persons are there in that representative suit, it is binded to everyone. Okay. And coming to the explanatory part 7, the provisions of this section shall apply to a proceedings for the execution of a decree, and reference in this section to any suit issue or former suit shall be construed as reference respectively to a proceedings for the execution of the decree, questions arising in such proceedings, and former proceedings for the execution of the court. Here, what you have to highlight here is the 7th point, that is execution of decree. Execution of decree. For example, execution decree also, their EP, that we can say EP in a practical matter, we say that after obtaining the decree, the person who got a favorable decree, so he is called a decree holder. So if he is filing the execution, subsequently he is filing the same execution proceedings in a different court for the execution purpose, now it is said to be a res judicata. It is applicable under the res judicata. What you have to highlight here is the execution of a decree. And coming to the explanation part 8, an issue heard and finally decided by a court of limited jurisdiction. Here you have to highlight limited jurisdiction. Limited jurisdiction, it decides such issue shall operate as res judicata in a subsequent suit, notwithstanding that the court of limited jurisdiction was not competent. As I said previously, when if it is subject to the objections to the jurisdiction, if the court passes any order and they cannot challenge it, because that is not having the jurisdiction. If the court has been passed any relevant order, now if it is comes under the limited jurisdiction, it has been finally decided, now it cannot be challenged. There is an exemption for this, there it cannot be challenged. Only in some exceptional cases it is applicable. Okay, and coming to the next part to understand illustration I can say you illustration. Let us consider few illustration to understand the doctrine of res judicata. I give two illustration to understand this concept. For example, you think, for example, A sues B for damages for breach of contract. A sues B for damage of breach of contract. The suit is now dismissed. You assume that the suit is dismissed. Subsequently, A suit by against B for damages for breach of the same contract now can be entertained in the court. No, right? It is barred. That is what A's right to claim damages from B for breach of contract having been decided in a previous suit, it becomes res judicata and cannot therefore be tried in the subsequent suit. B cannot be vexed twice for the same cause of action. It is already dismissed. Hence, it is said to be, B is having the, he cannot go for the, A cannot go for the subsequent suit because that court has been dismissed the case, and this is comes under res judicata. And this is also like it is clearly stated that it is adjudicated, though it is dismissed also. It is as you have to presume that it is adjudicated. Okay. And coming to the many cases, you can see no court dismisses. You can challenge it in a appeal court. You cannot file a fresh suit on the based on the same cause of action or based on the same parties. Okay. And coming to the second illustration, A sues B, C, D, and in order to decide the claim of A, so now A sues B, C, D. The court has to interpret a will. That is, the decision regarding the construction of the will on rival claims of the defendants will operate as res judicata. Here, A sues B, C, D in order to decide the claim of A based on the, in case any the court has interpreted any will. So already the court has interpreted the will. Now they are challenging. A is challenging on B, C, D. Now the decision regarding the construction of the will on rival claims of the defendants will operate as res judicata. They cannot go for the, it is already constructed. It has been changed. So now they cannot challenge it. Subsequently, the suit by any of the defendants against the rest cannot be challenged. Okay. It is not challenged. They cannot file the separate suit. Okay. And coming to the one more example, I can tell you. A sues B for possession of certain property, alleging that it has come to his share on partition of joint family property. A sues B for possession of certain property, alleging that it has come to his share. Okay, it has come to his share on partition of joint family property. B's contention that the partition has not taken place is upheld by the court, and the suit is dismissed now. So they are B saying that the partition is not upheld by the court. So now B's contention is wrong. A subsequent suit by A against B for partition of joint family property is not valid. Now he can go for the partition again. It is not valid because he is also having the right on the property. Now these kind of cases cannot be valid. Coming to the place of suing. Introduction. Suits may be different types. They may relate to movable property or immovable property. They may be based on contracts or torts. They may be matrimonial proceedings, suits for accounts, and so on. The jurisdiction of court to entertain, deal with, and decide suit may be restricted by a variety of circumstances. So suit may be restricted by a varieties of circumstances. And the first thing which is to be determined, the place of suing. The expression place of suing simply means the venue for trial. So if the place of suing is nothing but where exactly the suit can be instituted, it is venue for trial. It has nothing to do with the competency of court. So if any competence is there, it can be tried. Okay, place of suing. So you have to understand, based on the varieties of circumstances will come, different circumstances will come, where you have to file the suit. If it is coming to the question of filing of the suit, then you have to understand the person where he can file. So objections to the jurisdiction will come after this section 15 to 20, though I have explained it earlier to understand what is the objection. Now if you understand the objection, you will understand when the place of suing is coming to the question mark, so then you will understand whether the objection can be raised or not. Coming to the explanatory part, section 15 to 20 Code of the Civil Procedure regulates the forum for the institution of suits. Section 15 requires the plaintiff to file a suit in the court of lowest grade competency to try it. So section 15, if you open the Bar Act and if you can see that section 15 speaks about the file should be instituted in the lowest grade competent to try it. And what about section 16 to 18? It speaks about nothing but it's relating to the immovable property. If I ask you a question in future, like, where exactly the suits relating to the immovable property speaks under which section in CPC, then you must say the answer under section 16 to 18. Okay. 15 deals about the filing of a suit in a lowest lowest grade competency court, and coming to the section 16 to 18 that relates to the immovable property, and coming to the section 19 that is applies to the suit for compensation for wrong to person or to movable property. It is applies to the suits for compensation for wrong to a person or about the, simply you remember that movable property will come under section 19, and section 16 to 18 it deals about the immovable property. Got it? And section 20 that is residuary sections and covers all cases not dealt with in case there is any cases has been left where they are not speaking under the section 15 to 19, then section 20 gives elaborative meaning for the which they have left. Okay, here it is a residuary sections covers all the cases not dealt with under the section 15, where it is not applicable under the section 15 to 19, then you can see under section 20. And coming to the 21 and 21A, you understood that what that is a objections to the jurisdiction. Okay, it is section 21 recognizes well established principles that defeats the territory and pecuniary jurisdiction can be waived, and 21A it is bars the substantive suits for setting aside a decree passed by a court on the ground of want of territorial jurisdiction. If you can see the content of the Bar Act, so you will understand what exactly the sections. And coming to the nature and scope of section 15, what exactly the nature and scope of section 15, that is more referred to the pecuniary jurisdiction, correct? And coming to the mode of valuation, it is prima facie plaintiff valuation in the plaintiff that determines the jurisdiction of the court and not amount for which ultimately the decree may be passed by the court. Thus, if the pecuniary jurisdiction of the court of the lowest grade is the way of 10,000 rupees. So, pecuniary jurisdiction of the court, the valuation of the plaintiff, it determines the jurisdiction of a court, not amount for which ultimately the decree may be passed by the court. Thus, if the pecuniary jurisdiction of the court of the lowest grade says 10,000, the plaintiff files the suit for the accounts. Finally, the court finds and taking the accounts that 15,000 are due, the court is not deprived of its jurisdiction to pass a decree for that amount. As we have already discussed about this pecuniary limitation, in case it has been filed or in the court is having only competent to try the case only up to the 10,000 rupees. For example, a previency small causes courts, it is only having limited jurisdiction, that is only for 10,000 rupees, you think. Now, for in case if it is dealing for the 15,000 rupees regarding that 15,000 are due, then court is not deprived. Then court can pass it. Okay, so it cannot be stated that it is not having the competency. Some exceptions are there. Based on that, it can deal it. And coming to the territorial jurisdiction. Territorial jurisdiction types of jurisdiction are like this: suits in respect of immovable property, suits for movable property, suits for compensation for wrong, and other suits. Immovable property, you know that is section 16 to 18. Section 16 to 18 deals with suits relating to immovable property. That is, clause A to E of section 16 deals with the following 5 kinds of suits. That is, suits for recovery of immovable property, suits for partition of immovable property, suits for foreclosure, sale or redemption in charge upon immovable property, case of mortgage of suits for determination of any other right or to interest movable property. So these all are the section 16 speaks about. Section 16 under, again you have clauses, that is A to E. That is, what is A to E? You should please merely understand what exactly this section speaks about and where immovable can be recovered. So where you can file it under what section? That is suits for recovery of immovable. That is section 16 clause A. Okay, section 16b. If you open barrack, you will understand. Suit for partition of immovable property, section B. And suits for foreclosure or sale or redemption in charge upon immovable property or case of mortgage, anything. So that is comes under C. And coming to the D, that is suit for determination of any other rights to or interest of immovable property. So this is comes under section 6. Today I would like to complete this section, and tomorrow we will see elaboratively what exactly section 16 to 18 speaks about the immovable property, and section 19 about movable property.
డాక్టర్ చెప్తారా?